All right, hello everyone, and welcome to the Making Privacy and Consent Rules Work for Family Caregivers. Before we begin, I'm just going to go over a few things, but first introduce myself. My name is Catherine Monk-Sakel, and I'm the Program and Communications Associate here at the Foundation. I'm sitting here with Genevieve Obarski, who I'm sure all of you know, and Mary Jane Dykeman, who helped write this privacy paper. Before we begin, if you have any questions at all throughout the webinar, you can type it into the chat. Even if it's technical questions, I'll be sitting and helping to answer those technical questions if you have them. And I know you've all pre-submitted some questions, so Genevieve will go over those with Mary Jane throughout the webinar, and at the end answer any additional questions that you may have. But again, just everyone is muted and no one's video is on, so just ask any of those questions in this chat box. So without further ado, I will pass it over to Genevieve and Mary Jane.
Thank you, Catherine. Just changing seats here for a moment. Thanks very much, and welcome to the assembled Changing Care team, and those of you that are dialing in separately but are part of the team, and the privacy and risk folks at St. Joe's London. Thanks very much for taking your time this afternoon. We have to get cozy here to both be in the camera.
Both be in the camera.
Yeah. So just wanted to go over the agenda today. Just a bit of an introduction as to why the Change Foundation is interested in the privacy and consent issue. We're going to do a good overview of the privacy and consent legislation based on what was in the report. And then, of course, we'll have time for questions and answers. And as Catherine said, the questions that you've submitted previously, we've built those into the agenda. So, and if we don't answer those fully, feel free to type in the chat for clarification if you need it, and enter in other questions as you go. So first of all, the Change Foundation, over the course of a year in 2015 and 2016, we engaged with family caregivers and health and community care providers across the province to understand the caregiving experience in Ontario from both perspectives. We heard from caregivers during the course of this engagement that providers often told them that they couldn't share health information for privacy reasons. We heard from providers that they were uncertain sometimes about privacy and consent rules and who and when and how they could share information with. And both groups said privacy and consent legislation was often used as an overarching reason as to why patient information couldn't be shared between caregivers and the providers, sometimes even in cases where consent had been given by the patient. So along with our changing care themes, which we're all working on that emerged out of this engagement, separately, we noted this issue of uncertainty around privacy and consent rules. We heard from caregivers that they often have to make repeated efforts to get copies of health records from a variety of providers providing care to the person. So often they had to be the sort of collector of all the information, and it was difficult to get that. Sometimes the caregivers, even if they had consent, were refused access to copies of test results or health records, and sometimes ignored by providers when they had important insights and updates to provide about the patient's health, things that would have been helpful to the treatment plan or for inclusion in the medical record. So we hopefully are going to talk about all those scenarios throughout the course of our webinar this afternoon. Sorry. Okay, so our report is called Making Privacy and Consent Rules Work for Family Caregivers, a Change Foundation report that we put together in connection with Mary Jane, who will introduce herself in a moment. And it's basically a primer on the current legislation, which the consent requirements that are set out in the Healthcare Consent Act, and the collection, use, and disclosure requirements set out in the Personal Health Information and Protection Act. The report includes descriptions of legal tests for capacity to consent, and we'll talk more about that, rules about when you can collect and disclose and access personal health information, special rules for when the patient is deemed incapable to consent, and a little bit on the hierarchy of substitute decision makers. As well, the report contains 5 case studies to illustrate the application of the rules, and we'll go through one of those at least, and maybe 2 if we have time today, our webinar. And then the report also has information on where to go for more help, and we'll refer to that again in a moment. So I'm going to ask Mary Jane to introduce herself, and then we're going to get into right away into some of the content, and that includes some of the questions that you've submitted. So Mary Jane.
So thank you very much, Genevieve, and it's my pleasure to be here, and I thank all of you for joining and the Change Foundation for doing this important work. I've worked in the health sector for 20 years now as a lawyer on these two statutes, and I can absolutely understand that there are barriers that flow each way as people face these situations. So we're hopeful that by walking through the Healthcare Consent Act and PHIPAA, the health privacy legislation, that we can unpack some of that a little bit. I have had the good fortune of being in-house counsel to both a major long-term care home and a public hospital. I do a lot of work in community mental health and addiction, a lot of work with the elderly and across the sector. So we're hoping to draw on some scenarios that many of you may find quite familiar, and also, as Genevieve said, incorporate some of the questions that you've posed. So thank you for those.
So before we get into the actual body of the slides that we prepared, we want to address a couple of the questions that Jacoby collected from you guys and sent in to us. And I'm going to read all three of these because I think they're all related in a way. The question that we received was, given the new 2016 privacy legislation amendments to PHIPAA, what are the consequences of privacy breaches? And Mary Jane's going to talk about the breach reporting requirement. And the two other questions that you asked kind of relate to this. One is, as a caregiver, if you hear two healthcare providers breaching the privacy of another patient, what should a caregiver do? What are consequences of that behavior? And then a related question, if a healthcare provider is aware of another provider breaching privacy, what are the documentation requirements? Does that breach get documented in the medical record? So thank you for submitting those timely questions ahead of time. So I'm going to ask Mary Jane to speak to those now before we get into the rest of the content.
Okay, and you may have to remind me of number two and number three, but I'll start just a very quick note on PHIPAA. So it came into force, as you know, in November of 2004, but it was more recently amended, and those amendments under Bill 119 came through, I think it was last May, so May of 2016, and it did a few things. So for example, it doubled the fines under PHIPAA, and it's now up to $500,000 for an organization, 50,000, I believe, for individuals. I mean, we can compile some of this for you, but I think it may be 100 and $500,000. So one thing to remember is these fines have never been levied under PHIPAA. So that's important to know. But I imagine over time, as more and more of these breaches are happening, my instinct is the Information and Privacy Commissioner, the IPC, the regulator, is really running out of patience with breaching. People either know or ought to know what the privacy rules are. And there are imperatives about the duty to train the people who work in healthcare organizations and make sure that they know the rules. And that's fairly straightforward to do, but it's really important. And the IPC is also asking not only for training, but also awareness. So continually bringing privacy up as an issue. And again, I don't think we have to reinvent the wheel, but there are ways that organizations can do that by sending out updates and picking particular topics like, recycling versus secure shredding. Make sure your devices are encrypted. Don't snoop in the health record. That's probably one of the biggest ones. And there's been lots of press over that. So there's the doubling of the fines. The Attorney General has been given some further ability to initiate Attorney General prosecutions. And those had not happened for many years. And now there have been at least 5 in the health sector, and not only in large hospitals, in other smaller community settings as well. So these Attorney General prosecutions have gone forward primarily where someone has almost gone rogue, where it's the employee who has been snooping. They've mainly been snooping cases that have happened. So that's a significant issue. And there are some other things that are really not about Bill 18, but there is more media attention right now The colleges, the health regulatory colleges, are very interested in having their members maintain the standards. It can be professional misconduct with severe sanctions. There have been members of certain colleges that have lost their license to practice, for example. So it is a significant thing, and there have been class action lawsuits laid in a couple of prominent cases. For example, one where staff took it upon themselves to be selling personal health information of mothers with new babies to RESP providers. So that, in a nutshell, is those are some of the consequences potentially. And there are always the internal consequences. We always say discipline up to and including termination. And we don't talk a lot about who got terminated, but there have been terminations in the health sector based on privacy breaches. So that's just a quick way to address that. Now, you had very specific questions, including these new IPC breach reporting requirements, which took effect October 1st. And I can provide some further tools that we've developed. I think they may be helpful to all of you, just to make sure that you know that there's an online portal where you can report these breaches. There's a guidance document of the Information and Privacy Commissioner that actually sets out the 7 circumstances where you would be required to report. So there are certain categories, including patterns. If you see that there is a pattern of breaches, like errant faxes, for example, if it happened once in one area, that would be one thing. But if you're starting to see it emerging, someone asked me this morning, well, what's a pattern? And I said, well, I don't know if that means a couple, a few. I think we're going to have to work our way through it. But as long as you are aware that there are these new October 1st mandatory reports to the IPC in 7 circumstances, there's an online portal. They have a guidance document, and we will provide all of those links. There's also a requirement. You have to have good documentation, because in the new year, there will be a requirement to do an annual report of your breaches to the commissioner's office. So important to get things in place early.
So Mary Jane, if a caregiver or providers hear about a breach, is their first step to go to whoever's the designated privacy officer, and that person would do the reporting? Is that how it's set up to work?
Yeah, generally each organization will have its own rhythm and rules, but the privacy officer is usually central to the discussion. Maybe someone calls in and makes a complaint about their privacy being breached. Maybe your own internal systems catch a breach. The question that you posed was, well, what if you overhear a couple of other healthcare providers talking about a particular patient, maybe in a public area? We always encourage people, be very careful if you're on an elevator, if you're in a public place, if you're on public transit, if you're at home with your family. Clearly, you're not permitted to be having those casual conversations. So if and when there's a breach, you would typically reach out to the person. Every organization is a health information custodian. They will have a contact person, the privacy officer, and you really should have a privacy breach protocol in place as well. And this is what we find, that the commissioner will reach in, and you will see when you go to the online portal, the kinds of questions that they want answered. How many people are affected? Do we know? What's the scope of the breach? What kind of information, et cetera. So we'll just leave it there for this purpose, but we'll provide a bit more information as well.
And just one nuanced additional question that was submitted was, does that breach of a patient's, say, personal health information get documented in the medical record, or not necessarily? Is really the reporting arm through the privacy legislation and not so much as a documentation in the medical record? Is that what I'm hearing you say? Or
well, it's
could it be both?
interesting. I think it could be both. There's nothing that would prevent it, but typically, so there is a duty if, let's say, you're a patient and your privacy has been breached. So there's a duty under Section 12 of PHIPAA to actually let you know. There's a mandatory duty to give notice to the affected person. So we do that in a variety of ways. It might be appropriate if you are in a hospital bed to go and have a visit with you, and we would sort out who goes to have that conversation. If it's someone in the community, whether it goes by letter, perhaps it's a phone call. If it's not quite as urgent, maybe it's on the next visit, but you have to weigh out the privacy breach and the mitigation, and is there any risk still out there? So ultimately what we're saying is that the person will be made aware of the breach, but it's not necessarily the case. I'm not aware that it would have to be in the health record per se, but it is going to come to their attention because there's this positive duty to both give the affected person notice, as well as this new duty to report certain kinds of breaches to the Information and Privacy Commissioner.
Okay, thanks, Mary Jane. And if Mary Jane can maybe provide us with those tools, we can get those out to anybody. And if even after this call, you have questions about this
Absolutely.
topic, feel free to submit them to us and we will get them to Mary Jane to answer. So just now going to this first slide and into our sort of, regular prepared content, but thank you so much for those timely questions. Some caregivers are frustrated often that healthcare providers won't speak with them or just don't want them in the room when they're speaking with the patient. So who's right in that case and how do we navigate that?
It's a tough one because, of course, caregivers are often great historians, a great source of support. The patient may well want the person to be there. So usually we'll think about the fact that the healthcare provider may have some concerns about whether or not they actually have the patient's consent. So if I walk in with my mother and the body language is good and my mother's sharing information or directing questions over to me to answer, you may not have to unpack that completely to think, I now must read to you about PHIPAA and are you privacy compliant and is it okay that she's in the room? So I often say, informally, read the room. If there's any doubt about whether or not the person who's accompanying the individual is either taking it over in a way that doesn't make that patient happy, again, it's a read the room situation. And some healthcare providers will ultimately say, I'd like to have a quick chat with your mom. It's my practice to just make sure that that is fine. Or sometimes they might put it out to, let's say, again, it's my mother. They might say, well, Mrs. Dykman, isn't it great your daughter's here? Would you like her to stay, et cetera? So I think there is that informal approach where you're just basically reading the room to see whether there's any reason. I'm not always a big fan of inviting everyone to come to the table with their rights, to be quite frank, and I don't mean that in a dismissive way, but just so that, we don't have to unpack it for everyone, but we do need to, again, just assess whether there's any reason that you would ask the person to leave. I don't think that that is the norm. I think most providers would just rest on the assumption that if it's all going well, it looks good. If there is inherent tension, or when you're talking about information, it's clear that the patient is highly uncomfortable. We've had cases where patients have come back later to say, even though I said yes to that disclosure of information, when my spouse was there, I don't want you to. So again, I wouldn't necessarily go looking for it, but I do appreciate that there is frustration in it. There may be a informal way to handle it. One of the things I did want to say, there's a particular provision of PHIPAA that it's a bit obscure. And I worked on this legislation years ago. And I remember when this went in, and I think it's a good one. So there is a provision that says, if a healthcare provider is going to collect information and is a bit worried that, wow, I can't collect it because I don't know that I have the consent. The general rule is you're supposed to get the consent of the person. There's a provision that actually says, if you can't get it directly from the patient in a timely or accurate way, then you can collect it from someone else. So in theory, the healthcare provider, if they know about this clause, and a caregiver could gently remind them, well, I think you're allowed to collect it if you can't get it from my son in a timely or accurate way. Then the provider could turn to, let's say, that parent and collect some information that they wouldn't get otherwise. And this is not the same as a Form 1 under the Mental Health Act, because at law, if there's legal authority that says you can collect, then you can collect. On a Form 1 under the Mental Health Act, an application for psychiatric assessment, it already says that you can collect collateral information, so you're covered. This is just one extra way that a caregiver could remind the healthcare provider that, in fact, they are allowed. There is a bit of a catch if, let's say, the patient later comes in and says, well, I know that you talked to my parents. I don't want you to use it. Perhaps the healthcare provider would have a bit of a nuanced conversation, but ultimately that patient could say, don't use what you collected. But this does pave the way to collection. Another clause that we really want to put out up front is that a healthcare provider can always disclose personal health information to reduce or eliminate a significant risk of serious bodily harm. It's there in the slide, so you don't have to copy it down. To reduce or eliminate a significant risk of serious bodily harm. And that is a disclosure to any person. So that could be to police, it could be to the caregiver, to whomever. The healthcare provider has what we call a discretion to warn. It's not a duty to warn, but it is a discretion to share information if there's potential risk. So Privacy Commissioner in the past has always said privacy should not cost lives. So we definitely need to know. And again, a caregiver could gently say to the healthcare provider, if they're not aware of that, I think you probably can share certain things with me because, and so if you use the two together and you collected information based on timeliness and accuracy, and then the provider said, wow, I better tell you something, you know, there's a situation of harm, the provider could then disclose. And we've already commented on the read the room.
I just wanted to, still on that topic, one of the questions that was submitted around the issue of caregivers being in the room and submitting information. If the caregiver does take initiative and shares information, does the healthcare provider have an obligation to receive the information and document in the patient's chart? So what's the responsibility for the provider if the caregiver does voluntarily gives information? What's the obligation for recording that in the chart, or what's the professional standard there?
Right. So one of the important components of the professional standard is, so let's say a caregiver comes in and says to the healthcare provider, I have some really important information to give you. So that would be the first pause, because then we would be thinking of, well, am I going to collect it because I can't get it in a timely or accurate way? What is the legal authority to collect it? So if we clear that hurdle, what if the caregiver says, and I don't want you to tell the patient because he'll be upset with me, and I don't want you to write it down? PHIPAA is very clear. PHIPAA says that someone giving the provider information can't be done in a way that would thwart the professional standard to document. So I think the provider would have to gently say, assuming that they get over the hurdle of being able to collect it, or they may just say, you know, unfortunately, I don't have the authority to collect it, but if you'd like to get your son to call me or, you know, permit me to, then that's fine. But even if you went with timeliness and accuracy, then they can't say, don't tell him and don't write it down. Basically, if it's written down, I mean, you might not have to go and tell the person immediately because you had that other authority to collect it, but it certainly would be documented and that person would have a right of access.
Thanks. Okay, let's talk about strategies that can be used when a patient who's capable tells the provider not to share what might be important information for the caregiver. You know, how can we negotiate through this scenario?
I love this question. It is so important because what we don't want providers to do when they come to this impasse where a patient is clearly instructing, do not share my information with you, to take a pause. The healthcare provider might be able to initially have the conversation with the patient, again, in a more nuanced way to say, well, could we talk a little bit about why you're concerned that I might give information to your sister? I'm proposing to give only this amount, you know, maybe the patient's being discharged to home in the care of the caregiver. So it would be really important. In the health, it would be really important to have this information so they can support you. They're not going to get the full chart if that's the situation we're dealing with. So having a nuanced conversation about how providing the information would be helpful. Ultimately, the hard fact for caregivers is if if they're not substitute decision makers, we'll talk about that in a moment. If your person says no, ultimately the answer then is no, unless there's some authority like to reduce or eliminate a significant risk of serious bodily harm. Most times we're not at that juncture. So I say take a nuanced approach in the conversation. Don't just put privacy up as a stop sign. Have the conversation, and if the answer is no, again, what are the concerns? Can we reduce them in any way? Support of the person, and is there any middle ground? But ultimately, if the answer is no, then the answer is no.
Yeah, it sounds like the issue of privacy and consent, rather than, as you say, being used as a stop sign, should be seen as a yellow caution light to have a conversation.
Correct.
So yeah, if we could start,
I like that analogy
thinking
a lot.
about it. Yeah, well, when you said the stop sign, it made me think that it's really an opening for a conversation, because there's a lot of nuanced discussion.
Absolutely.
It's not all black and white. So
yeah, I think sometimes patients have a feeling that the entirety of their record of 10 years is going to be printed and handed over and poured over. And it may not be that. It may be some smaller portion for a specific legitimate reason, and there can be a conversation. So I like the yellow caution in that case.
Let's proceed, but let's get everything straight first. So what if you get to a point and the answer is still no, that the patient doesn't want to share information with the caregiver? What else can healthcare providers offer for caregivers?
Well, it's potentially small comfort, frankly, to caregivers when that no is the answer. But on the other hand, the healthcare provider can still provide supportive information for the family. And sometimes we pause to think about whether this is the first overture. So maybe it's a caregiver who is new to this provider, and you probably do have to take care in terms of, if it's information about diagnosis of dementia or schizophrenia, if the patient is instructing, don't share anything, the provider does have to take care in terms of sharing, I can give you helpful resources about dementia, unless they know that it's known. So there could be a breach already there. But most often the caregiver has been in and out of the situation, and there may be helpful resources the organization has on hand to help, because most organizations say they're patient and family centered. And sometimes it's tougher to reconcile those two when we know that patients in Ontario and Canadian law have certain rights of autonomy, and if they're capable to control their treatment and their flow of information. There is one clause that also can be helpful. In PHIPAA, it says, and this is only about long-term care homes and hospitals, there's some special rules that exist, those two organizations, where if someone calls the front desk, they can say, is so-and-so a patient here or a resident? And so based on implied consent, as long as this is in what we call a notice of information practices that every organization has, here's how we collect, use, and disclose personal health information. If that document is posted or available, then the default will be someone can call in to find out whether the person is there, unless they've withdrawn their consent. But it's an implied consent, and it's helpful in some of those residential settings. If you can call and say, hi, is my person there? Yes, she is. What's interesting to me is that it extends more broadly to say where the person is within that organization. To my mind, that's particularly intrusive. You would know whether I'm on a cardiac unit or labor and delivery or mood disorder or whatever it is. But that said, that's what the legislation says for now. So that's only for long-term care and hospitals. And then there's other opportunity to, as a provider, if you need to figure out who the substitute decision maker is, or find a friend or relative because you have this person here, you're allowed to use their personal health information to do that.
Okay. Thank you. So you mentioned the issue of capacity and to consent. We talked about, when somebody's capable to give consent, what are the nuances of that? But talk to us a bit about when a patient's capacity to consent, and is this consent for treatment or information sharing? And what's the difference in those two situations? If you could kind of walk us through the capacity issue.
So capacity is extremely important. There's a legal test that we're going to walk through in a moment. capacity is how we determine whether someone gets to make their own decisions. So people are presumed to be capable. So the healthcare provider doesn't necessarily have to do any kind of formal assessment. So we want to talk about both treatment and consent for the collection, use, and disclosure of personal health information. But we really started, including in the report, with treatment, because if the person is capable to consent to treatment, they may or may not be capable to consent to other sorts of disclosures. Same thing for the substitute decision maker. In the drafting, we decided to make it slightly easier. If there is a substitute decision maker who steps in to make the information decisions for that person, they automatically make the related information decisions. And that just makes sense. The good news is, and you'll see when we get to the test for legal capacity, it's the same test. And it is challenging in Ontario legislation because there are many different types of capacity. We sometimes hear, oh, well, she's incapable. And I always pause and say, well, what does that mean? For what? Are we talking treatment, capacity to manage your property, capacity to write a new power of attorney for personal care or for property? There are many different tests that need to be looked at. Right now, we're talking about treatment and flow of information, those information decisions. Age is not a factor on the treatment front. So just because I am 14 years old or I am 92 years old, there is no automatic finding that I am incapable to make my own treatment decisions nor my information sharing decisions. So that's really clear. We're going to talk in a moment just about some special PHIPAA rules around children for those of you who have youth clients. You can be capable for one treatment and not another. So I may be capable to consent to have my ankle set when I break it, but I may be incapable, I may be found to be incapable to consent to certain medication, antipsychotics. So it doesn't mean, there's no blanket finding of incapacity, whether through one condition to another or through the various types of capacity that one person could be assessed for. So it doesn't depend on diagnosis, even if I have dementia or schizophrenia or a cardiac condition, I am not automatically incapable to make my treatment nor information decisions by virtue of a diagnosis. And again, if I'm capable, I make my own treatment decisions and I can say no. So we don't usually canvass the room to say, has anyone made a lousy decisions regarding your health lately? People, if they're capable, get to make arguably poor choices. So that's frustrating, I think, to family members and caregivers and to providers who work get certain things in place for people who then end up losing some of their options by virtue of making poor choices. But if they're capable, that's what they get to do. And there are some rules around informed consent to treatment that, of course, apply.
So if it's not dependent on age or diagnosis, what is the legal test for capacity, and how do we determine if somebody's capable to make decisions for health information release or for various types of treatments?
So this is extremely important. It's very important for the healthcare providers, because if in the remote chance you find yourself at the Consent and Capacity Board, the first thing a patient's lawyer is going to do is to say, let me ask you about the test for capacity. Do you know what it is? Can you state it out loud? So this test is two parts. Both parts of the test must be met. And it's about my cognitive ability. So the patient must be able to do things. They must be able to understand the information that's relevant to the treatment and the decision to be made. And they must be cognitively able to appreciate the reasonably foreseeable consequences of saying yes or no. And that second prong of the test is sometimes where it falls down for someone. So I may be able intellectually and cognitively to understand the information that you're giving me about my condition, and you are proposing a treatment for me. So I may be just fine with that, and I meet that prong of the test. But the second prong of the test is the ability to appreciate the reasonably foreseeable consequences. And sometimes, in some circumstances, if a person is not cognitively able to appreciate the reasonably foreseeable consequences, if they have a condition that leads them to lack insight into their condition. And there are certain mental health conditions. I've seen, instances with the elderly, if the person doesn't know that they have the condition, then the second prong of the test is sometimes where it falls apart for that person. So it's a two-part test. You have to meet both prongs of the test. And it's a similar test under PHIPA. As I mentioned, we drafted them to be similar. Again, two-part test, cognitive ability, and that's about consent to the collection, use, or disclosure of information.
Thanks, Mary Jane. So let's move now into when someone is deemed incapable through these situations and tests, who is their substitute decision maker, and how do we come up with who that would be?
So I think we can go through this fairly quickly. The short answer is everyone in Ontario has a substitute decision maker. So you should all know, looking at this list, who would be your person. The caregiver might well be getting information with the consent of the patient, but if and when the patient becomes incapable to consent to treatment or for information sharing, all of a sudden the caregiver will need to know who's going to be the substitute decision maker. So everyone has one. Very few people have guardian of the person. That's a court process. It's costly. It's quite intrusive. So let's just set that aside. We see that sometimes in the developmental disability community. Attorneys for personal care, that is a person. That's not a lawyer. That's a person who is named in a power of attorney for personal care to make certain decisions. So as counsel to healthcare providers, we often, when we have this discussion, say, is there a power of attorney document? Can we take a look at it? Does it elevate a family member up above the rest? Number three, a representative appointed by the Consent Capacity Board. That is going to be extremely rare that someone goes to the board to outrank someone else or to be named if they're not even in the ranking. A neighbor could go. From number 4 down, you'll see it's primarily family members. So the highest ranked family members, and they all rank equally. So if there are 2 spouses, parents of a child, spouse or parent, a partner rather, you start with them. And I often have to pause and say, because we'll be dealing with, let's say, the adult children of the patient, and the siblings maybe are starting to duel a little bit about the decisions. I will often just say, did the patient ever sign a power of attorney for personal care? Was she married? And sometimes they'll say, and we're well into it, and they will respond, well, there is a husband, but he's not very engaged. And so I say, well, wait, we're going to have to pause for a second. So again, family members, number 4 down, spouse or partner. Partner can be same sex now in Ontario. The next one, child or parent. There's some special rules that we don't have to get into about the custodial versus the access parent and how divorce proceedings and custody proceedings can change that. So you need to watch for that, but we won't go into detail. Brother or sister, any other relative. And sometimes people will say, do I have to go to the ends of the earth to find a living, breathing substitute decision maker? And I think the answer is no. It's not a forensic science. I don't think you have to exhaust yourself, but I think it would be reasonable to ask the people around the patient some of those probing questions. Is there anyone else? Are there any other siblings? There always seems to be a sibling from away that didn't get accounted for. So ask those questions. And I can tell you, if we don't ask those questions, public guardian and trustee, being the substitute decision maker of last resort, will absolutely ask. Before they step in at the treatment decisions unit, they will want to know, is there someone else who could be asked to make this decision?
Okay, thanks. So why is it so important, Mary Jane, for caregivers to know who will be the patient's substitute decision maker?
It is important because it might be the caregiver, but it is not necessarily the caregiver. So I think the caution for healthcare providers is you want to know whether you are working with the correct substitute decision maker. Just because the caregiver has dutifully and constantly been the person attending with the patient, if and when there is substitute decision making involved, it may not be them. And that sometimes creates some tension. So I think it's just prudent for the healthcare provider to do a quick double check of that list and sort out whether in fact it is the caregiver, or maybe the caregiver has siblings or a spouse who would also make decisions.
Excuse me.
So again, the patient, while capable, was the one controlling the information and potentially permitting the caregiver to have certain information. And again, I think one of the issues that led to the Change Foundation writing the report was the fact that it was so frustrating for caregivers who had the consent of their person and yet were not getting the information they needed. So we're hoping that this equips both groups, the caregivers and the healthcare providers, and puts them on the same page. Complicating factor, of course, if you have a situation where the caregiver is not the substitute decision maker, then the healthcare provider is going to have to turn to the substitute decision maker to say, and is it okay if I share this information with your sister about your mother? And so the substitute decision maker can control and can actually stop the flow of information. So in most cases, that is not an issue, but there are some fraught cases where the substitute decision maker does slow down or stop the flow of information to that person who's been there at every turn, supporting, doing all the right things. There's a provision in the Substitute Decisions Act. If that substitute decision maker is also an attorney for personal care, we sometimes trot out their duty to foster important relationships and involve that person. But if there's no attorney for personal care, it's a family member further down the ranking, we just invite and try to persuade, and we want people to get along, but that's a bit of a challenge as well. And so bottom line, we're saying that the healthcare provider shouldn't hesitate to share information with the caregiver as long as they know that that's absolutely fine with the individual. So again, I'm not saying we would stop every patient and say, is it okay when your caregiver comes with you? Again, I'm back at the read the room. I know that doesn't seem like a formal legal stance, and I'm not trying to take people's rights away, but generally speaking, I think we can make some assumptions and then keep an eye open as well.
Thanks, Mary Jane. So we went through the list of kind of the roles in which people can be a substitute decision maker. Are there any other sort of parameters around who can be a substitute decision maker?
So just quickly, there are ground rules. So a substitute decision maker must be willing. So nobody is forced into that role. They could certainly say, no, I'm not going to be able to be available. I would rather that my sister do it, etc. They have to be willing. They have to be available. And this is where I think healthcare providers sometimes have some challenges, because for all of the many caregivers who are very actively interested in supporting the care, every now and then we get a substitute decision maker who doesn't want to engage. So I've always said, we'll try it a couple of times, but if there's a treatment that requires a decision, we don't want to wait forever. Public guardian and trustee has pushed us a little to put in writing, dear Mrs. Smith, we've tried on 3 occasions to set up a meeting with you for, a decision about the proposed treatment for your husband, Mr. Smith. We propose that there be a meeting next week, etc. And otherwise, to be a substitute decision maker, you have to be willing, available, at least 16, not prohibited by court order or separation agreement. You have to be capable. If you are not available, we will move on to the next highest ranked person. But the public guardian and trustee, before they get involved, want to know that you've engaged in that way. Because I think it is challenging. How would a substitute decision maker know what the rules are unless someone tells them? We often talk about the person's best interest. Well, how would I know what that is unless, I'm studying the Healthcare Consent Act? So the important things, particularly the willing, the available, capable, the substitute decision maker has to be capable, him or herself. Sometimes when someone makes a poor decision, I think, okay, did they make a poor decision for the patient because they're incapable themselves, or did they make the decision capably, but wow, it's a darn poor decision? Substitute decision makers don't get to make the poor decisions. And I know one of you had raised a question about, and maybe it's coming up here.
Yeah, I think the question that the group submitted ahead of time, it's kind of a 2-part question. So I'll ask Mary Jane to address both sides of that in this slide here. The question that was submitted was, when joint powers of attorney or substitute decision makers disagree about a care decision, So that's one scenario. And the second part of the question is, what about when one substitute decision maker or power of attorney is not acting in the patient's best interest, or even if there is only one POA and they're not acting in the patient's best interest, what does the healthcare provider do? So it's kind of a couple scenarios. What do you do when substitute decision makers don't agree? And then secondly, what do you do when one or more substitute decision makers aren't acting in the best interest of the patient?
This is a really good set of questions because they take you in two different directions. So the first one is, if you are equally ranked substitute decision makers, parents of a child who needs a treatment decision, siblings, the adult children of a senior patient, then you need that group to get it together and come to consensus. And I spend a ton of time in the background on these issues. So we need them, and we can gently but firmly say to them, we need a treatment decision from you. You need to come to consensus. You need to bring us your decision. And if they themselves want to, go and either get a new power of attorney, that's a bit dodgy in and of itself, depending on the situation. We deal with that a lot. But at the same time, if they want to go apply to the Consent and Capacity Board to be a representative, maybe that's what they'll do. But otherwise, we just gently say to them, we need a decision from you. I'm sure your mom would not want this situation. When you have that decision, bring it to us. Mm-hmm. And that is extremely important. They must agree. If they do not agree, we tell them, unfortunately, if you can't come to a consensus, the public guardian and trustee is the decision maker of last resort, but they are also the tiebreaker. So that usually gets it sorted pretty quickly, but you'd be surprised. It doesn't always sort the situation. So they must agree if they're equally ranked. Otherwise, the tiebreaker is the public guardian and trustee. And then the second one, let's just say it's one substitute decision maker and they are refusing a treatment that the healthcare provider is proposing that has, you've explained the risks and the benefits and the alternatives, and clinically you believe that this is a very good proposed treatment. It is possible, as I said, that person could be incapable. But let's say in which case they can't be the substitute decision maker, there's no appeal, you go on to the next one. If they're making a capable, poor decision, not in the best interest, which is defined, so they're overriding the patient's last capable wish, we've got a DNR situation or something like that they're going to override, you can make a Form G application to the Consent and Capacity Board, and that's an expert arm's length tribunal. They have to have their hearings within 7 days unless the parties agree. So the proposing practitioner is able to go to the Consent and Capacity Board. So in one case, public guardian and trustee is the tiebreaker for the decision. And then in the other case, it could be a Form G application. And I always try to make sure people don't have to go to the board, but sometimes we will say, unfortunately, if, we are concerned about this decision because we don't think you're acting in the best interest, which again is defined, we may have to take it to the Consent and Capacity Board to make the decision because this situation is quite tense. That sometimes, and again, it's not a threat, but it's a reality. That is the avenue for that person if you are quite concerned that they're making this poor decision not consistent with the prior capable wish or the values and beliefs. And I always say staff sometimes also get pulled into the family dynamics. They may come and say, well, did you know that this substitute decision maker did such and such? Or anyway, it can be fraught, so we just have to calm the waters and have a good discussion and then move on, because meanwhile this patient is waiting proposed by the practitioner. And I say they have to know that they will lose the authority if they can't come to agree.
So, did you have something else to say on that one?
No,
Yeah, just so Mary Jane, referred earlier about age limits for consented treatment and special situations for young adults, say, in treatment decisions. So let's talk about that.
Yeah, I'd like to do this one fairly quickly. We can dispense with consent to treatment in age because there is no age. There is the legal test for capacity. So the treatment,
talked about that, yep.
It's not about age. Information sharing in some ways, unfortunately, we deviated a little bit and created these special rules. So bottom line, if a child is 16 or over, he or she makes any applicable information decisions, consent to collect, use, or disclose. An example I sometimes use just to illustrate it, though, is if a child is under 16 and let's say they need a camp note signed off. So my 15-year-old son goes to camp. Do we think he really is going to be the person trotting off to the doctor to sign the thing? No, either of us can. But the exception would be for that child under 16, if that consent has to do with information arising out of a treatment decision that he made on his own, that I didn't make for him, that he made on his own, or counseling under the former Child and Family Services Act, those are a couple of exceptions. It would be him, not me. Probably to my chagrin, but that's where it is. So 16 and over, the child makes the decisions. Under 16, child or parent, unless the child capably consented to treatment. So we can always come back to that one, but it's just, if you have questions around youth clients, just maybe come back and have a look at this one.
Yeah. So any special rules around information sharing that apply in a mental health setting?
Yes. So just for those of you who work in mental health facilities, for example, so the standalone large mental health facilities formerly run by government, or mental health units within a hospital,
which they have at St. Joe's.
Exactly. Yeah. I mean, that's the part of the problem. It's with a couple of locations. So Section 35 sub 2 of the Mental Health Act sits in one statute and the PHIPAA rules sit somewhere else. But what sometimes people aren't aware of is, if you have a patient who is on a Form 4 and is involuntarily detained, who then instructs you, don't share certain information. I want a lockbox and I don't want, these 3 members of my team here in hospital while I'm involuntarily detained, or if I'm a forensic client, I don't want certain team members to have my information, or I don't want you to go and collect anything from my family members. Bottom line, Section 35 sub 2 sits in the Mental Health Act, and it actually permits you to collect, use, and disclose what you need. And there is no lockbox, and there is no complaint mechanism to the Privacy Commissioner, because they don't have oversight over the Mental Health Act. So you have some scope as a healthcare provider for a forensic or detained patient under the Mental Health Act. So the civil system or the forensic system, just know that it is there. So I already mentioned as well the Mental Health Act Form 1 application for psychiatric assessment. That authorizes collateral information to be collected as well. So you don't need special permission. That might be a point in time, caregivers, that you want to give as much information and that healthcare providers can pull as much as they have. But we did want to point those out given the populations you serve.
And I think we have enough time to sort of talk a little bit more about what a lockbox is, and can you kind of explain that a little more for folks?
Yeah. But quickly, you may hear the term lockbox. That doesn't exist in PHIPAA. It's not a term of art that we put in there, but it's generally used. The term that we did use is much more cumbersome. It's called an express instruction. So a patient generally can instruct the healthcare provider not to use their certain information, don't share it with other providers within this organization, or don't share it, for example, outside this organization with my addictions counselor or with the geriatrician or my family doctor. So there's a use and a disclosure provision, and it's basically locking down the information for purpose of those other healthcare providers. I think one of the issues is that patients will sometimes say, they almost like the privacy stop sign, they will put up the sign that says, I want a lockbox. I don't want anybody, anywhere, in any circumstance to have my personal health information. And that is not what a lockbox does. That's only the flow of information amongst healthcare providers. So it doesn't apply to all of those many collections, uses, and disclosures that happen under PHIPAA. If you need to report that someone cannot drive safely anymore under the Highway Traffic Act, if you need to share information to reduce or eliminate a significant risk of serious bodily harm You can share it with any person, police or the, intended victim. So there are many, many, many places where you are still going to share it despite a lockbox.
So let's just talk a little bit about what about things in the health record, a patient's record that might be about a family caregiver. What's the rights for access to the patient's health record? What rights does the caregiver have to that information that's in someone's personal health record?
Right. So if I go into the organization and the healthcare provider starts to write down my family history, for example, anything that I am telling about you, about anyone else in my life, that is part of my record of personal health information. So I, if capable, have a right of access, and the Supreme Court of Canada backed this up some years ago, and it's been written into PHIPAA. And it doesn't matter if you get a report that says, do not ever release it because it's a report of another hospital, you need the express consent of the other hospital. Not true. Inherent right, unless I'm going to go harm someone or harm myself based on what I read, the patient has a right of access to the record. It's very specific for the healthcare providers in terms of time frame, up to 30 days. It can be extended for up to another, but it's very specific in terms of the PHIPAA rules. In terms of the caregiver having access, because, by the way, I know that my son has been saying all kinds of stuff to the provider, then the answer is a gentle, unfortunately, that is not the case. You don't have a right of access. Mm-hmm. So sometimes we've had meetings where a caregiver, now it would be different if they were a substitute decision maker, they then take on the rights of that person. Mm-hmm. Let's say it's a caregiver who's brought the patient in and there's a team meeting, and the caregiver might say, but I know for a fact that you were writing while I was there. One thing to remember with access to the patient's health records is it's not even just what's in the health record, it's what you write down in meetings. If it's identifiable, it's a record of personal health information. So we always say to providers, you may want to take care, because that gray hardback book where you write all these notes about this patient identifiably and their family.
That's a health record.
Yeah, that is a record of personal health information to which there's access. So family history, no, it doesn't give rights to someone else unless you step into the shoes of the substitute decision maker.
So we're going to walk through a scenario now where you might come into some questions and decision making on sharing of personal health information. But I would encourage you, if you've got questions that came up, either we need to clarify some of the stuff you already submitted and we didn't answer completely, or if new questions have come up, feel free to put those in the chat, and we are ably assisted here by Pierre and Catherine, who will help us keep track of the questions. So I'm going to ask Mary Jane to kind of walk through the scenario and some of the places where there might be decision making about personal health information or consent, sort of applying the stuff that we've just talked about. But in the meantime, if you have questions that you want to chat in, please feel free to do that.
So I have a feeling that you probably all know Maria. So we've said that Maria is 85 years old. She has a diagnosis of early stage Alzheimer's. She has a husband. So back to my point of establishing, even if the adult children are bringing Maria to all of her appointments, who might step up eventually to become a substitute decision maker? Is there a husband? So we know already he's not very engaged in her care. Also not the legal test as to whether or not he would be asked to make a decision as a substitute decision maker if in fact Maria is incapable, which we're not into yet. Maria continues to live at home for now. We put that in with a bit of premonition that perhaps it's not going as well. And you will recognize this cycle of person living at home. Maybe the yard is starting to look a little neglected. Newspapers are piling up. Neighbors are starting to wonder, is Maria okay? And is she okay living at home? There is a local daughter who is nearby, coming in and out, medical appointments, among other things. So she is the caregiver for as much as we know at this point in time. And now we're saying, if and when the healthcare provider proposes a treatment, who is going to make treatment decisions for Maria? So first of all, Maria is presumed capable. So just because she has a diagnosis of early Alzheimer's and I didn't say early onset, so I'm presuming, again, she's 80 something years old, she's in the early stages of it, she may well be able to make her own decisions. So if she meets the legal test for capacity, or if there's no formal assessment, you don't, as a provider, ignore the obvious signs, but you're allowed to rely on the assumption that she's capable. Then we turn to the fact that she's capable. Her daughter, Rochelle, brings her to an appointment. She's upset that the test results haven't been sent over. And this is often hear from caregivers. Again, they tend to be quite good historians. Anyone who has accompanied Maria into a healthcare setting may find out that, wow, the provider got some information, but a lot of it is not accurate, or there are more details that are pertinent. And so again, as long as Maria seems fine with it, you can collect good information from Michelle to fill in some of the blanks. Sometimes the barrier is that information is not flowing as it should. So sometimes caregivers will express, I can't believe I had to, there's no central electronic record. I had to start over. I have to carry with me the list of Maria's medications, et cetera. Her test results should have been here, but they're not here. I'm going to have to bring her out another day, et cetera. So that's part of the frustration. The original provider is saying they need to sign consent to transfer the records over for the appointment. So even if it could get solved on the spot, which is a question, they're saying, no, our process is we need Maria to come in and sign a consent, et cetera. So, I mean, there's nothing in PHIPAA that says a consent has to be in writing. It can be an express consent, but it can be verbal or it can be written. Lawyers love written consents, but I think common sense has to prevail. If there's a discussion going on, maybe you put it on hands-free to say, Maria, would you be okay if they faxed it over right now because you and your daughter are here? So again, consents don't have to be written. If you get a verbal consent, of course, and I mean, you need to know what the policy of your organization is, but if you get a verbal consent ever, then you make sure that you document yourself. So then the next piece is who would give consent for the information to be shared? Again, this would be if Maria, let's say Maria is incapable. And then we're in that awkward moment where, okay, Rochelle is there, George is not. Are there other possible substitute decision makers? Let's say George is unwilling or unavailable or potentially incapable. Are there other possible substitute decision makers? There is a provision not used often in the Healthcare Consent Act that you could rely on Rochelle if Rochelle says, look, nobody equally ranked to me or above would mind. We use that a little cautiously, frankly, because sometimes it can be misapplied. So we don't usually start with that. But in this situation, I would say, I think we can rely on Rochelle. Maria tells the provider that Rochelle will make all of her treatment and information decisions. Can you rely on this? And this is a bit nuanced because under the Healthcare Consent Act, I can't delegate treatment decisions to Genevieve. A treatment decision is made by the capable person, either Maria or if she's incapable, whoever we sort out to be her substitute decision maker. So if it's treatment, and if Maria were to say, well, I would just prefer that Rochelle make the decision about my treatment, you would probably have to say, well, Maria, the law says it has to be you, but you can certainly involve Rochelle in the conversation and she's here to support you, et cetera. So there is a difference. For treatment, you can't delegate. For information, you can. Often, Maria might come to your office and say, oh, I don't care about that. Just talk to Rochelle. Rochelle can give you all that information. That's just fine. You could document. She says she's fine with Rochelle, giving the information or giving the
getting
consent.
Information,
getting the consents that are required. So that hopefully cuts through some of the barriers as well.
So kind of walk through some scenarios on Maria, and I think we have a little bit of time, unless people have questions that they want to submit right now. We'll walk through a scenario with Andrew, and this is more of a kind of mental health case scenario. We'll walk through this, and in the meantime, if you have questions, please submit them.
Okay, so this is Andrew, and we'll tell you a little bit about what we've attributed to Andrew. So Andrew is worried that the healthcare provider is going to share his information with his parents. And this is not an unusual scenario. So let's say he has first episode psychosis, or maybe a long-standing mental health history. I'm not singling out mental health. This just happens to be the scenario. So Andrew's already saying, I don't want you talking to my parents. I don't want you to listen to them. I don't want you to believe what they're telling you. And I don't want you to tell anything back. This is my information. It's private, etc. So the first question we posed was, is there a difference between a parent telling the provider something? So the caregiver is saying, provider, I know you can't tell me a whole lot because of patient confidentiality, but I have a bunch of stuff that I need to tell you that will be quite helpful to Andrew's situation. So let's go back for a moment to where we talked about earlier the ability of the healthcare provider, because the general rule is you have to find the legal authority to actually collect it. You're meant to collect it straight from Andrew. But remember I said, if you cannot collect it in a timely or accurate way directly from Andrew, let's say he is in an episode of psychosis, then you could turn to, and again, accurate or timely. If you know that you can't get it in an accurate way from Andrew, you could, in fact, turn to the parents. But you want to make sure that you're documenting what you're relying on. Because otherwise, Andrew, and again, as we said, Andrew could come back in a couple of weeks and say, I can't believe that you shared that information with my parents, or that you took information from them. You know, maybe they're recounting how when he was discharged from hospital and returned home, things didn't go well. So timeliness or accuracy is one thing. So there is that almost dichotomy between the ability to collect and looking for the authority to collect the information that someone wants to give you versus disclosing a lot of information to them. And you, again, always have that ability to disclose the information to reduce or eliminate a significant risk of serious bodily harm. Do not let privacy cost lives. If Andrew's likely to harm himself or harm someone else, then obviously you're going to move very quickly. And again, the provider may be worried about breaching privacy. We've talked a little bit about the consequences. Mm-hmm. Again, document, why it is that you shared it, within professional standards, et cetera, and the organizational policies should be fine. Does Andrew's age matter? As I mentioned, treatment is not about age. Mm-hmm. It's not about diagnosis. It's about legal capacity, but this is about information. So the only carve out is if he's 16 or older, it's going to be up to him. If he's under 16, if it's an information decision, can I submit something to the insurance company, for example, or to his employer? I mean, that would be express consent no matter what, but it could be parent or child. And in this case, let's say he's 14 years old, maybe that just works fine. But if it's information about a treatment or counseling that he consented to, then it goes right over to him to make any decision about the information after that. What if Andrew is on a Form 1 under the Mental Health Act? So again, application for psychiatric assessment, there is that inherent component, which is the ability for a healthcare provider to collect collateral information. And it is there for a reason. You have the person on the Form 1, they come in, they're going to be there for up to 72 hours to be observed, assessed, et cetera. At least you have the ability to collect the information that you need in order to help with the observation, assessment, examination of Andrew. If on a Form 4, I only wanted to tie it back to what we said about Section 35 sub 2 of the Mental Health Act. If you're on a Form 4, you're necessarily going to be in a psychiatric facility, and in certain psych facilities. So if you're in a Schedule 1 facility, all of a sudden you're in this situation where you have more ability to collect information and to use and disclose it vis-a-vis a patient who's involuntary. And you might say, well, why do their rights get reduced? But at the same time, they are detained under legal authority for them to shut down the flow of information required to support their care when they must be there. They don't have the right to leave. If they're a forensic client, they're under the review board jurisdiction, or they're, subject to the Form 4. So they can't just get up and leave, but the corollary is they can't shut down the flow of information either. So it's not that you get information all over the place, you get what you need. PHIPAA is all about the general limiting rules to say you collect what you need, you disclose what you need to, etc. So that just gives you a little wiggle room. And we've already just talked about the lockbox, I think, so we don't have to. I guess the answer is he may or may not get a lockbox depending. So here's a pattern that you may recognize as well. Let's say he's discharged from hospital, he comes home and he takes treatment that's been proposed. Things are looking good for Andrew. He starts to improve, he feels better. Just as he feels better, what do you think happens? He starts skipping the medication and then he stops entirely. And unfortunately, the behaviors return, and then we've just put a few notes in about, well, what might be the next steps for the family who, at this point, the caregiver is somewhat distraught, and you're back to the same legal mechanisms. Form 1, application for a psych assessment. Any physician in the province who's seen the patient within the past 7 days can sign a Form 1 if he meets the criteria under the Mental Health Act. Sometimes Andrew will not have seen a doctor. Let's say he's at 10 days and he hasn't seen anyone, so there's no Form 1. Sometimes caregivers will make notes and then go to a justice of the peace. That is sometimes fraught, just because Andrew may find that to be, a bit of a betrayal, but it is there for a reason. Anyone can go. It could be neighbors. It could be a team amongst the healthcare team. Like a group could make notes and then go do that. And then there are the police powers. If all else fails, if the behavior descends into a situation where police might be called, police have powers under Section 17 to the person to hospital, and then you would start the Form 1 process, and then, up to 72 hours. And maybe if he meets the criteria, he would stay, or if he doesn't, he would go or remain as a voluntary patient. So again, I underline up to 72 hours because sometimes families and caregivers will assume, they've heard 72 hours and they tend to think that they're going to get a 72-hour respite, because sometimes the situation has really unfolded in a way that is very tense. And finally, police bring the person or take the person away, and next thing you know, they think they get 72 hours, and 20 hours in, with no warning, Andrew shows up on the doorstep at home because he didn't meet the criteria.
Yeah, let's talk about the special situation where someone knows they may be in and out of sort of the, ability to make treatment decisions or decisions about consent when they're well. What can they prepare for times when they may not be capable?
Yeah, so there is a little known, fairly intrusive tool. We sometimes call it a Ulysses contract, and it sits in the Substitute Decisions Act. And it means that, for example, if, let's say I have a really bad episode, and again, I'm like Andrew, I'm refusing my medication, the situation deteriorates, eventually maybe police get involved, or by whatever means, I get to hospital, get on the Form 1, maybe I stay in hospital. Eventually, I'm going to be discharged. And I think, wow. And then, of course, I have rights to appeal all of this to the Consent Capacity Board, and there's mandatory rights advice. So all of a sudden, this process goes on for a long time. A year later, I think, wow, I've lost my profession, or I'm going to have to work to get my way back into it. My life has been heavily disrupted. I could arrange with a lawyer to do one of these Ulysses contracts to say, it basically means, and the reason they call it the Ulysses contract, remember the, person being tied up and don't listen to the siren song and everything else, or else we're going to crash the boat. The parallel is, I could say today, having lived through what I lived through, or maybe I've never lived through it, but I have a family member who's had a mental illness, and I think I never want it to get to that point for me. So I could actually go to a lawyer and draw up this contract that says, don't listen to me in the future when I say I don't want treatment. So again, these are quite rare, but it is one tool. Again, sometimes for people who've had cyclical bouts of mental illness to, make their way through if and when this happens down the road, so they don't lose another year of their life. But again, you'd have to, as a caregiver, you'd have to get the person to agree to that. And it's at least a mechanism that, could change the outcome a little bit.
Thanks very much, Mary Jane. That kind of concludes our regular sort of set of slides, et cetera. And we're hearing from Harpreet that there's no questions coming from the room, and we don't see any others right now. I just wanted to refer to one other question that we got in ahead of the webinar, and that was, how do we educate frontline providers and caregivers on this privacy and consent information? And I would refer to the last page of our report. There's several resources there, and I'm going to ask Mary Jane to talk a little bit about another one that I don't think we have listed on the report, but that's the CMHA toolkit. Can you talk a little bit about that?
Yeah, so the report has a number of great resources, including the Information and Privacy Commissioner and some others that I think will be very helpful to you. There are a number of toolkits that exist in the sector. So the Ontario Hospital Association, the Ontario Medical Association, years ago when PHIPA came in, got together, wrote a toolkit. It's fairly huge, hundreds of pages, I think. I think there is one for social workers as well. And you can always Google and find some of these tools. And I was fortunate enough to assist with CMHA Ontario's provincial effort back in the day, and we updated it this year. I think it was 2005, then again in 2017. And even if you don't work in mental health, it's a plain language. Here's a description of the act. Here's some FAQs, et cetera. So it was always online at privacytoolkit.ca, but it's one of a number. And again, the IPC Privacy Commissioner is looking at different ways to get the message out, because they are very focused on the training component. And, I applaud the Change Foundation to take on the issue from the point of view of the caregivers, because I think ultimately we all want people to have the same information and the same rules, and that graceful way through to engage in the conversation, and again, not to be frustrated where consent's already been given and then you don't get the information, and to be very fair to the healthcare providers, not to have them be in a situation where they feel what we call privacy paralysis, that they know that the stakes are now higher and there are class actions and attorney general prosecutions and doubling of fines under PHIPA and everything else. And the college is on us and the press is asking. So people, not surprisingly, have some trepidation around privacy. And I do think that healthcare providers want to do the right thing and not misstep. So this effort, the report, was really, I think, working toward consensus and responding to some of what the Change Foundation was hearing out in the field. And those issues, I think, have existed for a very long time. And again, I think we're making some progress in them. This was never meant as an initiative to go forth and change the law entirely. That's for a different day. But to really focus on what the Healthcare Consent Act and PHIPA say, and this kind of standard problems that we see through the sector, and hopefully can equip both caregivers and healthcare providers to solve and to work together on.
So we hope that the Change Foundation's report, our work that we're doing locally in the Changing Care projects, and this webinar, which we are recording, so it will be available if it wants to be used in the St. Joe's Changing Care project to educate other providers, or even if they're not in the project. And we will also be having some public webinars that people will have access to. So all that information will be available to the project managers and as people need it. So thank you very much for your time today. And we appreciate the questions you submitted ahead of time. And hopefully we've elucidated those for you. And I think we all feel a bit more comfortable about at least starting conversations around
Exactly.
privacy and consent armed with this information. So I think we're going to be signing off now as we don't see any questions. And thank you very much for your attention this afternoon. We appreciate your participation.
Thank you, everyone. Bye-bye.